Sir, thank you very much for the opportunity that has been offered to me to speak on this small amendment. Sir, when this parliament discussed the 42nd amendment, the biggest controversial amendment, it was said that the legislative competence of the parliament cannot be questioned in the court of law. That triggered the controversy. Ultimately, it was settled down later by the virtue of 44 amendment. The legislative capacity of the parliament cannot be questioned in those days. That was nailed down. Now, the capacity of legislative, parliament's capacity of legislation became a mockery through this bill. Sir, I do not know how this bill was drafted without giving any due care for the legislative competency of this parliament. Sir, ever since this government, BJP government came into power, the parliament is being misused. Most of the state subjects were brought to here for enactment of laws encroaching the state power. Ultimately, state autonomy became laughing stock. Cooperative federalism becomes the laughing stock. Sir, it is a small bill, but I am not able to understand the way in which the nationalism was put up everywhere, even in the Advocates Act. The Honorable Minister says colonial law. Yes, colonial law, 1879, the provision is there. You want to repeal it. But by way of repealing, you are introducing the same section, importing the same section in the new law. What does it mean? Is it not anti-colonial or colonial law? I am not able to understand the rationality behind the government to bring this law. Again, sir, the simple reading, how a person can be listed as a tout. Explanation, I quote, the passing of a resolution declaring any person to be or not to be a tout by majority of the members present at the meeting. Who are all the members in the committee? Nothing mentioned. Who are all the members? Then, by evidence of general repute, by evidence of the general repute, evidence must be tendered by a person who is having reputation in the society. All right. The next sentence is very dangerous. Or otherwise. What happened in Article 356? On the recommendation of the governor, a state government can be dismissed on recommendation of the governor or otherwise. That otherwise was used by the president when the Tamil Nadu government was dismissed without government recommendation. Such a dangerous provision for small advocate acts, you are putting same otherwise here. How it is going to be used or misused, nobody can say. Then, come for the meaning for tout. Who procures in consideration of any remuneration moving from any legal practitioner? What does it mean? Money will go from the pocket of the advocate to the tout. See, this house many times discussed at length about the corruption. The Prevention of Corruption Act says, periodically it has been amended that not only the receiver, the giver of the corrupt money also culprit under this act. He has to be convicted. The tout is going to be eliminated and given imprisonment or penalty. Does it not mean to say the person who is giving money also liable for the offense? What type of justice you are rendering to the A and B between the money is exchanged? So the very purpose of the corruption, Prevention of Corruption Act itself is defeated here by way of the way in which the bill is drafted. Sir, next one. The first time I have come across a bill that has been submitted to the parliament, may be correct or may not be correct, I may be correct or may not be correct, that objects and reasons were not at all given in the bill. For what purpose we are going to introduce, give this amendment? Whether the Bar Council of States, whether the Bar Council of India, is going to be consulted when a person is going to be listed as tout or not? What will be the role of the Bar Council? Sir, Chief Justice of India, a decade ago, Justice Bharucha said in the open meeting on the eve of his retirement that the 20% of the judiciary become corrupt. He made an open statement. The only problem for the litigant is a man is having case in a particular court, whether that judge comes under 20% or 80%, how does he demark it? So you want to revamp the entire judicial system, the cleanliness, right from doubts to up to judges. But you small matter, you are not able to draft a clear law, purposely to serve the purpose. So what type of purpose is going to be served? Nothing. Sir, ignorance of law is not an excuse. That is the legal maxim. A person cannot claim, I did not know the law. But what about the society? The society, still 30% of people are illiterate, so far as law is concerned. Again, so far as law is concerned, more than 70% of living persons are unaware about the legal system. So in such a situation, yes, you want to regularize the system of doubts, frame some guidelines, reasonable guidelines, but permit or either not permit. A healthy discussion must be there in the all forums, including the Bar Council of India. Sir, suppose a junior advocate, not a junior advocate, advocate on record. You are designing advocate on record. After the examination done by the Bar Council of India or Supreme Court judges, a man has been designated AOR, advocates on record. A senior advocate designated by High Court and Supreme Court cannot be advocate on record. No, I'm not. See, AOR is separate. Senior advocate is separate. Who is approaching senior advocate? Litigant? No, AOR. The role of the AOR, advocate on record, becomes almost similarity with the doubt as far as the senior advocate is concerned. So, a judicial system needs some middleman to bypass every pole in the judicial system. Whether that must be eliminated or that will be regularized with the rational application. That is a question before this House. I think that this bill is having no meaning at all because you are completely just mechanically transport a section which is available in 1879 Act to the new Act without application of mind. My only question is, what type of exercise that has been done by the government? Or what type of inference that has been drawn after this 100 years old law? Whether this provision is essential, the potentials, the provision is workable or not, practicality of the provisions has been appraised or not. Nothing has been done by this government, but everything you want to say, you want to remove the corruption in the name of Narendra Modi, starting from small bill up to big bill. So my only thing is, don't make this parliament a laughing stock. Don't do the meaningless exercise for which the competency of this parliament is undermined. So revisit the law, take back this law, draft carefully, try to revisit, try to regularize, or try to make a system which is workable in the judicial system. Thank you, sir. Very good. Shri Kalyan Banerjee.
Thank you, sir. I will bring the attention of the, I want to bring the attention of the Honorable Law Minister through you. First question is, really, every categories of touts in the field of the law have been brought within the ambit of this statute. Is it correct? Tout is there in everywhere, lower judiciary up to Supreme Court. A bill practically identifying persons who are in the subordinate or district court. What is the real bring to identify the tout? I understand this bill is reply what Mr. Raja has said just now. replacement of the old provisions of the Legal Practitioners Act. Nothing more than that. You are taking that colonial. I have no difficulties. But when you are making an attempt to bring this bill, you think broad. There are a number of touts. Sir, I tell you one thing. It is very easy to identify tout who are poor. Among the poor, how much touts are there in the judiciary who are extremely sophisticated? Can you identify? The process you have started, I understand, appreciate. But the reality is this: tout is everywhere. Tout is sophisticated. Tout is there. Tout is here going to 5-star hotels. Tout is there going to 7-star hotels. Tout is taking you in different places of the country. You can't identify that tout because they are sophisticated. They are coming from very big universities. They are having Mercedes. You can't identify that touts. You can't identify. That's exactly I am telling that you are not, this is not a broad, you are not bringing all types of touts. Today when the discussion is there, let the discussion. I know it will not be done now. Think in future about this. No doubt about it. Where is this tout, Sylvia? You know, sir, what do we know about this? We are laws. What are the laws? Statute law. Correct? There is a law, case law. This is the laws are known to everyone. Statute law and case law. Applicable in the court. All we proceed. There is another law, which is called face law. And face law is the important for having an order from the higher judiciary, highest judiciary. That's the practical thing. And for the face law, litigants have to spend lakhs and lakhs rupees. You have to invest 20 lakhs, engage 20 lakhs rupees lawyer, you will get the order. Touts are everywhere. Who are the touts? That's the whole difficulty. Identification of tout is necessary. It is very easy to identify a poor man. He is a tout. A lawyer is a tout. Talking about is a tout. But identify, take this system, bring this system, introduce a system to identify real tout in the judiciary, in the judicial system itself. It's correct what has been said. It's correct. It's an everyday's experience. Our judiciary has become, this is today, India, it has become too much expensive. Too much expensive. Unless you engage a very big face in the Supreme Court, you can't have an order.
Good money, good law, good justice.
Good money, good law, good justice. This is the practical thing in the country. That's going on. What is going on? You identify, sir, I will request you. You have come, you think real tout is where? Real tout is, sir, no one amongst the, there are one grade of lawyers are there amongst them who are trying to, who possess themselves that I am the bridge. I can bring the judgment. I can bring the order from the highest court. I can bring the order from that judge. I can bring the order from that judge. Come here. I will engage him. I will engage him. Don't worry. Sitting in 5-star, everything is settled and everything is getting. He is the main tout. What is the procedure? How you are identifying it? Since you have brought the bill, I have got the chance to speak. And I am speaking. This is I was thinking for decades together. What is going on? I am a man of practical field. I am looking into these things. And these types of touts I will not tell all the judges, but of course, there are very few judges are there in our country, having a very good relationship with them. In their dinner party, they will go. In their lunch party, they will go. Their marriage anniversary, they will go. They will go. We know everything. Everything is known. Someone speak for 2 minutes or 5 minutes face. Face law is very important in our country today to have an order. to get the justice. And who is getting that? The rich people are getting, not the poor people. Do you understand? Can you think about this country today, this judiciary is? Why the crores and lakhs poor people are not getting justice? Pending before the Supreme Court? Decades after decades. But Supreme Court is very much concerned whether there would be a marriage of the same sex or not. Therefore, Constitution bench will sit and they will go on hearing days in, days out, days in, days out. Peculiar things, sir. Sophisticated pupils, rich people, their problems would be entertained by the Supreme Court. Peculiar thing. I tell you, sir, do you know this same-sex marriage, whether it will be done or not, within 3 days, bench has been constituted, matter has been heard, everything has been done. Do you know, for long 27 years, 7 judges bench of the Supreme Court is not hearing one matter which really pertains to the poor agriculture worker of the West Bengal. Can you imagine? For whom we exist? Do we exist for the purpose of, whether the judiciary exists for the purpose of resolving the problem of the most sophisticated or a very sophisticated things, or the rich people? Sir, I tell you one incident. I'm taking your time. I'm sorry. Chief Justice Dattu was sitting. I was sitting on that day. I will not take the name of a very senior lawyer, very famous lawyer. He went and he wanted to mention a matter of one industrialist. I must say, Chief Justice of India, Dattu said, Mr. So-and-so, I have a number of matters of poor workers and poor peoples of this country. I don't have time. Simply because you are appearing for the top industrialist, leaving aside everything, I have to take up your matter. I have heard it. But today's approach is different. Peculiar. I am not taking any name. Big corporates. Go, big lawyers. Give big lawyers. Go, mention, his matter will be taken up. What is happening in our country? Poor people are ignored. This is the place. That's the... Sir, I must say, this is going on. Sir, point is identified tout and non-identified tout. You are here, mayor making. You are trying to identify the tout. But the big arena, big places are there, big field, where non-identified tout is there. Nobody will tell them. Because they are not taking tea in the street shop. They are taking tea in the 5-star hotel. Though they will not be identified. Sir, identification, how can you remove? Highly paid lawyer comes out. They accept it. Don't worry. 50 lakhs. Don't worry. Get the order. Order is coming, engaging someone. He is not there, engaging someone. And that's because of face law. Come. This is happening. Tout is there. Tout is also there today. This problem is. I am coming to a very relevant question now. Tout is there when relatives of any judge is in the field of practice, legal practice. Tout is there. Taking the name of the judge, relative is also holding out threats. It has come into the newspaper. I do not want to take. I do not want to take name. It is coming in the newspaper. It is under investigation. Let it be investigated. So since I have got the chance, I just tell you lots of, sorry. I just want to tell you one thing. I don't have the Honorable Law Minister, I don't have any difficulties regarding any transfer. I don't have. I want it. I wish it. I want that there should be a policy. Unless a policy is there, transparency would not be there. Whatever is the policy, you transfer anybody. How? I am not concerned. Give a policy. At least 140 crore peoples of this country will understand this is a policy. On that basis, transfer would be made. But today, what is happening? Picking up, transfer. Picking up, transfer. If relative is practicing, for that reason, transfer all the judges who relatives are practicing in any high court. Why you are bringing a judge into the Supreme Court, High Court to Supreme Court, knowing fully well that his relatives is practicing in the Supreme Court itself? Why? Why picking up the names? If I am unfit, if I am dishonest, if I am not fit for anything in any court, I am not fit, I am not for any other high courts also. Point is very simple. Then again tout comes. No. Tout will say, this is the problem that has to be addressed. Of course, I support, sir, your bill. But I am on a very larger issue to save the Indian judiciary. If for future generation, I am almost at the fag end of my career, legal service. How much? Yes, 8 or 10 years, how much? But save it for generation after generation. The pain which I have faced, the things I have seen, problem is this, I have told somewhere, the judges, why they are saved? Supreme Court judges, High Court judges. I can criticize, only here I can criticize because of the privilege of the Constitution, because of the existence of the Contempt of Courts Act. Because they can't criticize, no one can criticize any judge's activities, judge's thing. Otherwise, he will be hauled up for contempt. Our judges of the country are saved only because of the contempt of court. Don't think everyone is perfect, everyone is correct. There are so many persons. I take it, I used to take it earlier, it may be some aversions. Sorry, today I don't take it. It's an aversions. It has become a great disease of the Indian judiciary. That disease has to be resolved. I know, you are having a limited power, limitation, I know. But this is the field, this is the place where I can tell my words. Let the highest court of this country take note of the contents which I have said. Thank you, sir.
श्री एन रेड्डप्पा जी, आप नाम भेजिए प्लीज, अपना नाम भेजिए. श्री एन रेड्डप्पा जी, please send your name, then I will give you a chance and then you will speak. No.
Thank you, Speaker sir, for giving me the opportunity to participate in this discussion. To introduce the Advocates Amendment Bill 2023.
Please.
There is nothing to oppose in the bill. I fully support it. This is a welcome step. Advocates, for the important part of judicial system, they are not only the officers of the court, but also from the important bridge between those who seek justice and those who are empowered under the law to give justice. These amendments of Advocates Act were long pending and bring about a critical reform in the justice delivery system of our country. The importance of these amendments cannot be understood, and while these amendments are important, questions can only be raised as to accept on the consultation behind empowering the state agencies to act against liars, and secondly, the enforcement of a mechanism that will be required implement of this law. This is because while we want to that so-called Munna Bhai liars punished procedure also be needs be brought about the ensure that there is no unnecessary prescription of any genuine liar, and through these amendments the independent judiciary is not hindered with, sir. One of the most crucial important of the justice delivery system in India is its human resource element, which is the advocate. The role cannot be overstated in the whole process. The act as bridge between the aggrieved and the adjudication institution. They also play important role in shaping our society and not forget their role against the courts to arrive at several judgments protecting the environment. Sir. In 2017, two years ago, verification of drive by Bar Council of India found that only 50 to 60% practicing lawyers in India were genuine. This number was heavily reported in media. There needs to be a single public register for advocates across the country, which can be accessible by the public to across verify the claims of education qualification for each advocate they wish to engage with. Sir. Advocacy may look like a very glamorous profession, but for those who are in public practice of law, it is for them the truth, sir. The Advocates Act needs to be further amended to ensure that certain benefits of social security are also extended to the junior advocates, and to ensure that the advocates of the profession can retain the best talent in that there is no profession regarding this, sir. I would like to suggest the Honorable Law Minister to take steps ensure that first generation of advocates are also will benefit from the targeted government schemes for health and housing and other methods of to them to be able to earn respectively for their livelihood, sir. Despite of the important Acharya profession, these are not concentrate measures to place to ensure their social security, sir. Even new lawyer in New Delhi has to pay around 15,000 rupees for enrollment fee at Delhi Bar Council, charging fees beyond that what is prescribed under Section 24, subclass 1, subclass F of the Section Advocates Act 1961, violate the right to equality under Article 14 and denies opportunities the uprising advocates, sir. I am requesting the Honorable Law Minister regarding enrollment fee of advocates. They are not in a position to pay advocate fee also, sir. In this regard, central government has to take some steps to provide minimum financial assistance to the rural advocates, particularly to construct their houses, to have bank loans, and to pay enrollment fees and etc. Sir. Regarding in Andhra Pradesh government, our Honorable Chief Minister Y.S. Jagannath Reddy is giving 5,000 rupees each junior advocates, all the advocates in Andhra Pradesh in every month, sir. There we have to appreciate the Andhra Pradesh government also, sir. Apart from this, I am requesting the Honorable Union Minister to strengthen this Amendment Act and also to implement the ideas of Dr. B.R. Ambedkar, which are in the Constitution. Union government has to take steps to introduce All India Judicial Service to implement, particularly to appoint judges in all the courts, including Supreme Court, to at least When all India judicial system is there, they are going to impartial like IAS, IPS people. They are going to render some service to the rural level people. Otherwise, people from expected clients, they are not able to get justice from these courts. Therefore, I am requesting the Honorable Union Minister kindly introduce All India Judicial Service in the country. Apart from this, regarding touts also, touts anywhere, any court, on all the department touts are there. It is not possible to curb them. It is not possible to us to take any action against them through law also. In this regard, the union government has to take steps how to curb the touts system in all the systems, in all the governments in India level. Therefore, thank you very much for giving me the opportunity, sir.
Shri Bhartrari Mehtab ji.
Thank you, Chairman, sir. At the outset, I should make it very clear. The bill is relating to advocates. Bill is not relating to courts or high courts or Supreme Court function. Our attempt while deliberating on this amendment bill is to strengthen the advocates of our country and the system of jurisprudence in our country. This advocate amendment bill clearly mentions two things. One is to repeal all obsolete laws of pre-independence acts, not totally, but which have lost their utility. This should be borne in mind. All the law is not being abolished. Those laws which have lost its utility are being removed. And Government of India is doing this in consultation with Bar Council of India. So these two things have to be borne in mind when we are deliberating on this subject. We know the history of Indian High Courts, how it was formed by a enactment of British Parliament in 1861, and subsequently what development has taken place in between. While going through the bill, sir, the definition of tout is also given. A tout means a person who procures in consideration of any remuneration moving from any legal practitioner. The employment of the legal practitioner in any legal business. This is the first part of the definition who the tout is. But subsequently, in the second subpara, it is mentioned, the purpose of such procurement frequents the presence of civil or criminal courts or of revenue offices or railway stations, landing stages, lodging places, or other places of public resort. So in that respect, it has been very clearly mentioned in the bill that those touts who operate for lower courts, they need to be apprehended, they need to be named, they need their names to be published, and they can be prosecuted. The impression of the government is, or the earlier law was, that touts do not exist in high courts. They don't exist in Supreme Courts. We should not presume that touts do exist. But my only humble suggestion is that a beginning is being made. It was there in earlier enactment, which is now getting incorporated in this amendment, in the Advocates Amendment Law through this bill. And the best part is the previous law which was there, now one cohesive law is coming into existence. This was introduced in Rajya Sabha last August. It was passed in also Rajya Sabha last August. It amends the Advocates Act 1961. This bill repeals certain sections related to touts under the Legal Practitioner Act of 1879. The bill provides that every High Court, District Court, Session Judge, District Magistrate, and Revenue Officer not below the rank of District collector can frame and publish list of touts. This bill makes the act of tout punishable. Means cases can be filed against them, they can be apprehended. But there are two aspects on which I would like to deliberate. One is the practitioner or the legal practitioners, the advocates, what need to be done for them. And the second is about 45, Rule 45 also is mentioned, that is relating to regulating legal education. That also needs to be looked into, which has not been addressed in this bill. There is Rule 36, which imposes three primary restrictions on lawyers. Firstly, lawyers are not allowed to promote themselves directly or indirectly. Second is, if a lawyer is involved in a case, they cannot advertise themselves in the media, newspapers, display their photo, or make inspirational comments. Question is, who is going to question the lawyers? Who is going to lodge a complaint against this type of dereliction of duty? Our expectation is the Bar Council of India will take cognizance of it and will deliberate on it, will take action on it. But are they doing that? During last 20, 30 years since the inception of Bar Council of India, how many such cases has been deliberated by the Bar Council? Not a single complaint has been lodged, or has it been lodged and it has been glossed over? In consultation with the Bar Council of India, government is repealing the Legal Practitioners Act of 1879. Now the legal profession will be regulated by a single act. It is their responsibility to have quality lawyers. Section 36 of the 1879 Act is incorporated in the Advocates Act 1961. Some suggestions I have to make here for consideration of the government. Reform is a continuous process, and it has to be done with tune of time. There should be provisions for professional development of the lawyers in the Advocates Act 1961. There is no such provision even today, that how professionally an advocate can enrich himself. Technology has become all pervasive now. There are many emerging frontiers of law. Law to regulate telecom sector, law on intellectual property rights, Arbitration Act are some of those. Now, online dispute resolution has become a practice. Lawyers need to update with the latest development in the field of technology. Shouldn't we bring in these aspects in our amendment? How to legalize, how to make them more professional, that aspect we are missing. There should be, I would suggest, there should be, government may consider, there should be a national electronic register for advocates. Anyone, anywhere in the country can sit down and find out who are the advocates. Why should they take the help of touts? Or why should we presume that without a middleman, we cannot approach a lawyer? We do not have any such register. The Law Commission in its 184th report had suggested as such. There should be a single database. This would be good to bring social welfare schemes for the lawyers also, because you have a single database of the whole country. There should be a digital interface between the advocates and the clients. This will eliminate the need for Section 45A in itself. Why do we need middlemen when we can have an electronic platform that can connect advocates and clients? I have a query also. Do we need intermediary that is being incorporated as Section 55 in the Advocates Act after repealing Section 36? When we have digital interface, is this provision necessary? Finally, I would also for an Advocates Protection Act. Since states have enacted such law, Minister for Environment, Forest is also present here in this house. Rajasthan has enacted that law. The present law minister is also from Rajasthan. Rajasthan has enacted a state law. I'm not aware how that law is functioning and how much protection this advocate protection law has given. But it, but I think it is necessary because at times we also come across number of news where lawyers are attacked or lawyers are threatened or intimidated. Advocates need to practice fearlessly. The advocates, after all, are officers of the court. They are important stakeholders in the administration of justice. I believe the suggestions given shall get utmost attention of the government. The other part which I would like to mention is relating to the academic, regulating the legal education that needs to be strengthened. Large number of law colleges are being opened. But what is the quality of the lawyers? We all know. When the quality of the lawyers that are coming out from the law colleges, it is not only affecting the bar, it is also affecting the bench. So keeping that in mind, I think it is of greater need to look into these aspects also and to bring a comprehensive law in favor of the advocate and our advocacy system. Thank you, sir.
Shrimati Supriya Sule ji.
On behalf of the Nationalist Congress Party, I stand here to speak on today's bill of the Advocates Amendment Bill. Sir, Meghwal ji has been a colleague to all of us and a pleasurable colleague for a long time. And he was the colleague who brought in the Women's Reservation Bill. And he's really lucky that he has brought in a bill, though it's not implemented. But he's lucky that in his legacy that he will leave behind, he'll be one of the finest ministers who has brought something which is very close to our hearts. And I'm not taking away his intent of this bill which he has brought in. I have only a few suggestions. I'm not a lawyer. Most lawyers have spoken before me. But the intent of the government, I'm sure, is very clear about what they want to do. But I have a few suggestions and questions to ask them regarding the implementation of this bill, which is actually really small. But there are a few questions I'd like to ask the Honorable out of my lack of legal knowledge. Is this that he says, what is a tout? Now, Mehtabji has spoken about it, and so has Sri Raja from the DMK. But I seek a clarification from the Honorable Minister that he says that, which already Mehtabji has read, that who procures in consideration of any remuneration. So it's a one-sided thing, any remuneration. So it's a one-sided thing. See, in the Corruption Act, both parties are considered to be making a mistake. Here, you are only considering one party to it. So should we not make it broader? And whoever engages or whoever hires, both ways, I think the practice is wrong, right? So why should only half the person be punished? So if you are really trying to remove touting completely, why not include both the parties, is my question. So if he could kindly clarify on that. The other question for me is that who are the members present at every meeting? There is no clarity of it. In 45A, they've written that the explanation is the majority of members present at the meeting. Now, who will be the members? Who will decide what will happen at the meeting? Who will decide just with such a small thing? Who is a tout? And who will be taking the decision? There is no clarity about this. Now, this is like Rajaji said, I'm reiterating the point, but there are no objects in the bill. It's probably a little, I mean, it's a lawyer's bill which has such poor drafting, unfortunately, because there is a bill has to have its objectives. So there is no objectives in this bill. So what is the real reason of getting this bill? I'm again not taking away from the intention of the government. I'm sure the intention is, but when you are doing something for lawyers, isn't drafting and implementation most important than not just intent? Life is beyond intent. The other thing is about reforms, which Meghwal ji said. Sir, I have never dealt with lawyers in my whole life, but in the last 6 months, I'm flooded with lawyers in my life, be it Election Commission or Supreme Court. And there is a saying in Marathi, sir, if with your permission, I would like to say it, that in Marathi they say, जो होशियार होता है ना, वो कभी कोर्ट की सीढ़ी नहीं चढ़ता है. जो होशियार है, तो कभी कोर्टाची पैडी चढ़त नाही. अभी मैं होशियार नहीं हूँ, अभी मानना पड़ेगा, मैं तो चढ़ चुकी अभी. There was no option. So I had no option but to climb it. And clearly when you go to court, there are a lot of issues that are raised. The tout issue is discussed. But my whole point is there are a lot of reforms required in the court. I mean, justice delayed is justice denied. I don't want to go there. I know that's not the purview of the bill. But even one major point is injustice anywhere is a threat to justice everywhere is what Martin Luther King has said. So I think this is a very broader role that we need. We really need to expand this bill. The course of this bill, which whenever we meet young lawyers anywhere we get, you go to states, like somebody from YSR Congress, Jagan Mohan Reddy ji's party said that they are giving 5,000 rupees a month to young lawyers. In Kerala, they give, I think, 2,000. So is there something to engage all these youngsters who are studying very hard to pass it? So is there some social program this government has in mind, like most states are doing? That is my first question to this government. To reiterate, which technology upgrade? I think with technology, so many things are happening now. So is the entire game for lawyers going to change in the next few years? So how do they skill themselves better? I mean, this whole thing about colonialization has been discussed. So it's a past, it's okay, good or bad. I think it's not been that bad on it. So let's not just criticize our history. The way forward is change, and change is inevitable in everybody's lives. And that's what policies also. Policies also have to change with time. Look at the life today, something like artificial intelligence, something we didn't even expect. A mobile phone we didn't expect about 10 years ago in our lives, which has actually changed our lives. So every profession is changing. So are the lawyers. So is there something this government has in mind for technology upgrade of all the lawyers? The Protection Act, which Mehtab ji talked about, I'd like to take it a little forward, that many governments all over the country, not just talking about advocates, but they are even talking about doctors and press safety and security, because somehow I do realize, and we must all put our minds together in this government and in parliament, that there is somehow so much anger in society nowadays. I don't know where this anger is coming from, sir. Even in Maharashtra, we are having a lot of challenge. I'm not trying to digress, but I'm just giving you a small example. Please don't misunderstand what I'm saying. There are a lot of agitations going on in Maharashtra today on reservations, be it Maratha, Dangar, Lingayat, Muslim Arachans. Lot of stone pelting is suddenly happening. So there is clearly some anger beating somewhere. You hear doctors getting beaten up. You hear threats like Mehtab ji said about lawyers. There are press people who are getting beaten up. So there is something missing somewhere, sir. I think this entire House Parliament with legislation, we even need to discuss all these social issues, because the intent of changing people's lives for the better is what, that's why we get elected and come here. So at policy level, the intent of the government to bring in to removing of the touts is a very welcome step. Sir, the only thing when I was hearing about touting was, aapko bhi yaad hoga, hum log sab the, तभी तो मल्टीप्लेक्सेस थे नहीं, तो वो टाउट्स खड़े रह के वो टिकट सिनेमा की बिकते थे, 10 रुपया का 100 रुपये में टिकट, भी वो आईपैड वगैरह नहीं था. That whole touting business is over, because first day first show, life out of us is over. So technology does evolve life, so it will probably eventually do remove touts, but till then, can we do something better, which is simpler, positive, and like Meghwal ji said, Raja ji said, I would like to reiterate their points that why not bring a compressive bill, bring it, we could put it into the law ministry. The law minister is very fine. He's very supportive to all the demands of women that he did for us in the women's reservation bill. So I'd request him to take this back. Let's all take all the points suggested by all the renowned lawyers in this house, bring a more comprehensive bill, take all the feedback, maybe send it to a standing committee. There are good lawyers, even in the, I think the environmental minister is also a lawyer, if I stand corrected. Maybe some feedback from him also as a lawyer, and have a more comprehensive bill in the larger interest of the advocates of this country. Thank you, sir.
Shri K. Sureshi.
Sir, give me opportunity to participate in this bill. Sir, let me begin by quoting Mahatma Gandhi ji, who himself was a lawyer and an ardent champion of justice. An unjust law is itself a species of violence. Arrest for its breach is more, so states Gandhiji. The court means that any law must be aimed at delivering justice and vacating grievances of the oppressed, and if a law is unjust, arresting someone on the basis of the law is a form of violence. So the law has to be just to itself first. It is the context of the bill and my speech. The bill titled Advocate Amendment Bill 2023 is aiming at the insertion of new section, which is section 45A in the 5 of the Advocate Act 1961, which grants power to frame and publish list of touts to every high court, district judge, session judge, district magistrate, and every revenue officer not being below the rank of collector of a district. Each as regards their his own call, and the courts, if any, subordinate there. I have certain observation and recommendation in this regard, which are follows. As per the law, the authorities empowered to frame and publish a list of touts as provided under section 45A should be confined to only judicial authorities and not executive magistrates. If the district magistrates are given such power to frame rules, we cannot ensure transparency in finding out actual touts as defined under section 45(7)(b) of the amendment bill. Sir, similarly, the offense under the amendment bill as provided under section 45(6) may be cognizable offense and the penalty be enhanced to minimum 1 year and fine at least 10,000, or else no purpose would be served. Apart from these suggestions, I would like to ask the government, through you, sir, that who is the tout and what are the benchmark that you will use to identify a person as a tout. It is absolutely agreed that touts are a menace to the courts and justice system. What about people who would be implicated as touts when an excessive power is given to the courts? Any innocent person could be branded as tout, and that will be a dangerous situation. Sir, the question here is, we live in a highly polarized nation, divided by hatred and intolerance and discrimination. In this scenario, if excessive powers are given to the officers of the court to determine touts, anyone could be expelled from coming to the court premises. For example, a Dalit could be branded as a tout just because he is a Dalit, and the officer belonging to the upper caste and harbors discriminatory behavior towards Dalits or other communities. Another aspect is the amendment bill does not take into account any standard procedures for fixing the modes of appeal for a person branded as a tout other than appeal. This mechanism is problematic at many levels, as appeal system in many occasions is found to be biased, and therefore I demand that a committee must be consist representative of SC/ST community so that communal representation is ensured. I hope the Honorable Minister will agree my suggestion. Apart from this, I would also to be add that there are many issues concerning the legal system, including the reservation for scheduled caste, scheduled tribe in appointment of judges, the higher courts, which has been long-standing demand for many decades. I would like to appreciate Honorable Minister Sri Arjun Megwal ji, who is coming this ministry. So he also always for fighting the cause of untouchable people. In this law ministry, in your period, you have to take so many mechanism for the representation of SC, ST in the Indian judiciary. I also demanded that young advocates of SC, ST community must be given necessary stipends and financial support systems during their practice, and juniors, as they are finding it difficult to survive in the present condition. The demand for High Court, the demand for another important demand I would like to bring your notice, our long pending demand for the High Court benches. So in various states, there is a demand for High Court benches. In Kerala also, long pending demand to set up a High Court bench in Trivandrum. So I would like to request all the ministers to consider our long pending demand. Sir, furthermore, I would like to conclude saying that the amendment aiming to identify and expose doubts must not become a tool for opposition of any individual, and justice in the fairness must be implemented. With these words, once again, I congratulate Honorable Minister Sri Arjun Megwal ji as a law minister in this country to bring this important legislation. Thank you very much.
Thank you. Shri P.P. Chaudhary ji.
धन्यवाद सभापति महोदय, आपने मुझे इस महत्वपूर्ण बिल पे बोलने का मौका दिया। मैं इस बिल का सपोर्ट करता हूं और मैं चाहता हूं कि माननीय सभी सदस्य इसको सर्वसम्मति से पास करें। मैं धन्यवाद देता हूं माननीय मेघवाल साहब को कि इस बिल को आप लेकर आए और इस
The role of advocates is being limited by means of the legislation. The government has to take care, because strict legal interpretation nowadays, it is very difficult. Even the Honorable Supreme Court Judge, Chief Justice, has already observed that it is very difficult to understand and interpret the verbatim or the legal drafting of the laws made by the parliament. This is the situation. Even the judiciary is not able to have a good interpretation or understanding of the law made by the parliament. At the same time, most of the times we are trying to limit the role of the advocates in the legal proceedings, and thereby so many authorities are, in almost all the authorities, I'm not going to cite the examples, all the authorities, the advocates' role is being limited. That has to be looked into. That is one of the one of the issue which I would like to highlight. And another one is regarding, sir, most of the members, the previous speaker has also spoke about it. Because Kerala Advocates Act, we know that the Advocates Act is meant for the regulating the profession. Along with this, Bar Council is also part and parcel of this act. So we have to keep the welfare of the advocates also. We know the legal profession, we know the medical profession, almost all other professions, internship allowance and so many other things are there. As far as the junior advocates are concerned, in Kerala, we have a phrase that there are 4 stages in a profession of advocacy. Sir, 1 second. 4 stages. First stage is the raw junior. There is no case, there is no fees. The second stage is there is case, but there is no fees. The third stage is there is case as well as fees. And the 4th stage is the super senior stage. Thereby there is no case, but fees is there. This is the 4th stage of an advocate. In local language, we are saying it. So what my point is that the junior advocates have to be protected by providing some internship or stipend allowance, not less than 25,000 rupees for getting something has to be done. Because in house urgency, internship, in so many other things, we are providing such type of, after PG degree examination, the medical examination, we are providing all these amenities. Similarly, the junior advocates have to be protected so that they will maintain the profession in the proper way. And there's so many other posts, because executive posts in which law degree has to be made compulsory. Sir, my suggestion is, as far as the station house officer, A station house officer has to be well aware with the laws, especially the Criminal Procedure Code, Indian Penal Code, and the civil law. They have to be well versed with. But unfortunately, most of the stations, house stations, we know very well that they are not fully aware of this. So, as far as the SHO, the minimum qualification of a station house officer should be having a legal degree, that is an LLB degree, that should be made compulsory for all such type of executive posts. And the last point which I would like to highlight is, as far as the medical profession, we have made the proposal for having a law is there. Most of the 22 state legislative assemblies have made laws for protecting the safety and security of the medical professionals. Sir, same thing is happening in the case of advocates also. That is from the police forces. In my state, in Kerala, in Trivandrum bar, in Kollam bar, and in High Court also, so many conflicts are being taken because police is brutally attacking the advocates, and the police is interfering into the profession of advocacy profession, and no protection is being provided. In such a way, we have to think of giving safety and security in the discharging of the profession as an advocate, especially from the police forces.
Yes.
Now, series of incidents of violence is being happening in various parts of the country. That has to be dealt with, for which also the government has to think of formulating some legislation so as to protect the interest, safety and security of the advocates in discharging the functions as a legal professional or an advocate. With these suggestions, I would like to support this once again with these clarifications. Thank you very much, sir.
Thank you, Honorable Member Shri Adhir Ranjan Chaudhary.
Sir, taking advantage of this discussion today, I am goaded to participate in this bill under the nomenclature, the Advocates Amendment Bill 2023. Sir, already number of a long list of members have participated and made their valuable suggestions on this particular legislation. So the issue is that legal profession, it has already undergone a long evolutionary process in our country. Sir, legal profession has been in existence since the ancient times. Then the head of the groups or tribe delivered justice under the open sky before all the members. There was no specialist like a lawyer during those days. When kingship was established, the king delivered justice with the help of his religious head and wise courtiers. During the British period, the model legal system was developed in India. The Indian High Court Act 1861 passed by the British Parliament enabled the Crown to establish high courts in India by letters patent, and these letters patent authorized and empowered the high courts to make rules for enrollment of advocates and attorneys. All India Bar Committee was constituted under the chairmanship of Justice S.R. Das. The committee in its report recommended the establishment of an All India Bar Council and State Bar Council. So the legal profession, we must acknowledge the fact that the legal profession is an important limb of the machinery for the administration of justice. Without having a well-organized profession of law, the courts would not be in a position to administer justice effectively. Sir, also, the judiciary still is being treated as the last resort of the affected people across the nation. Sometimes I feel that common people are losing their reliance upon legislature, upon executive, and gradually they are going to resort to the judiciary in order to address or redress their grievances and their problems. So the legislation should ponder over this growing phenomena insofar as our legal mechanism is concerned. Sir, the issue is that the government is intending to bring this legislation with an intention which has been depicted by the government in this bill, that to repeal the Legal Practitioners Act 1879 and to amend the Advocates Act 1961 by incorporating the provision of Section 30. We must say that still the legal and the legal professional mechanism should be more streamlined, should be more strengthened. Sometime in our own experiences, we are facing various kind of hassles and intricacies in order to execute our political activities also. जब सियासत के चलते, राजनीति के चलते कोर्ट की दर्शन होने पड़ते तो पता चलता कोर्ट के अंदर की लफड़ा क्या है, कोर्ट के अंदर की समस्या कितने हैं, और कोर्ट में हम जैसे लोगों को जो बाहर से कोई केस में इंप्लीकेट होकर कोर्ट में जाते हैं तो वकीलों ने और कोर्टों की दलालों ने हमें मुर्गा समझते हुए जितना हो सके नोचने की कोशिश करते हैं। ये बिल्कुल सच है, ये बिल्कुल सच है। लोग कहते हैं कि अगर शेर ने आपको हमला किया तो 12 या 13 चोट लग सकते, लेकिन कोर्ट और वकील ने, पुलिस ने अगर हमला किया तो आपको 18 से ज्यादा चोट लग सकते। तो इसी के चलते मुझे ये सलाह देना चाहते हैं हमारे कानून मंत्री को कि अब गरीबों की बात सोचते हुए, आम जनता की बात सोचते हुए ये लीगल एड प्रोसेस को और मजबूत करो। लीगल एड फॉर पुअर एंड वल्नरेबल पीपल should be strengthened in a manner so that the entire process could be helpful for them. That is why I thought it prudent to at least put forward some of the views of the common people that touting वकील, ये सारे जो मुद्दा है हमारी ये कानून व्यवस्था से जुड़े हुए, इसमें और सुधार लाना जरूरी है। वकीलों की, टाउटों की, और बीच में जुडिशियरी के बारे में कोई टिप्पणी यहाँ किए गए थे। मुझे लगता है इस तरीके की टिप्पणी करते समय हमें और सावधानी बरतना चाहिए, क्योंकि जुडिशियरी और एग्जीक्यूटिव और लेजिस्लेचर ये हमारे संविधान में एक चेक्स एंड बैलेंस के हिसाब से हम देखते हैं। ये कॉन्स्टिट्यूशन की इंटरप्रिटेशन करते हैं जुडिशियरी, तो जुडिशियरी पूरा भरोसा रखते हुए हम सबको इस तरीके के कानून बनाना चाहिए कि जुडिशियरी हम पे हस्तक्षेप ना कर पाए। इस तरीके की चूज दुरुस्त अगर कानून हम बनाने में सक्षम रहे तो ये चेक्स एंड बैलेंस मैकेनिज्म, चेकमेटिंग जो मैकेनिज्म है, ये और इसमें और ज्यादा असरदार होगी। तो सर, मैं ये जो विधेयक लाए गए हैं इसको समर्थन करते हुए मेघवाल साहब को ये कहना चाहते हैं कि गरीब लोगों के लिए ये लीगल एड प्रोसेस को, लीगल एड मैकेनिज्म को और थोड़ा चूज दुरुस्त कीजिए। ये सलाह देते हुए मैं अपना वक्तव्य को विराम देते हैं और बिल को समर्थन करते हैं।
Thank you. Shri Imtiaz Jalil.
लेकिन बिल अधूरा है, और इस वजह से अधूरा है अध्यक्ष महोदय, ये जो टाउट का डेफिनेशन दिया गया है इस बिल के अंदर, टाउट का मतलब ये है कि पर्सन्स हु प्रोक्योर क्लाइंट्स फॉर अ लीगल प्रैक्टिशनर इन रिटर्न ऑफ मनी। टाउट्स का मतलब दलाल हो सकता है, बिचौलिया हो सकता है, या मिडलमैन हो सकता है। और ये बिल इन दलालों को, इन टाउट्स को पेनलाइज और पनिश करने के लिए लाया गया है। इसके अंदर अमेंडमेंट लाया गया है। अध्यक्ष महोदय, मैं ये पूछना चाहता हूं कि क्या सिर्फ इस बिल के जरिए हम जो दलाल है या जो टाउट है उसके ऊपर ही एक्शन ले रहे हैं, या वो दलाल किसके लिए काम कर रहा है, क्या इसके बारे में सवाल नहीं उठना चाहिए? क्या वो सिर्फ अपने क्लाइंट से पैसा खींचने वाला है, या जिसके लिए वो लेके जा रहा है उस एडवोकेट के लिए, तो क्या उसके ऊपर भी कोई एक्शन होना चाहिए इस बिल के अंदर? इसके बारे में भी जवाब होना बहुत जरूरी है। अध्यक्ष महोदय, यकीनन यहां पर आज जो डेफिनेशन दिया गया है कि ये टाउट्स कहां पे मिलते हैं, तो आपने बताया है दे फ्रीक्वेंट प्लेसेस सच एज द प्रेसिंग्स ऑफ द सिविल और क्रिमिनल कोर्ट्स। सिविल या क्रिमिनल कोर्ट के अतराफ में ये बिचौलिए दलाल होते हैं, रेवेन्यू ऑफिसेस के अंदर होते हैं, या रेलवे स्टेशन के ऊपर होते हैं, और ये ग्राहकों की तलाश करते हैं। अध्यक्ष महोदय, ये बहुत गलत है। ये टाउट्स आज हर गवर्नमेंट ऑफिस के अंदर आपको मिलेंगे, और बड़े अफसोस के साथ कहना पड़ता है जहां कानून बनाए जाते हैं शायद उसके अतराफ में भी ये टाउट्स आपको मिलते होंगे। इसीलिए आज अगर पुलिस डिपार्टमेंट के अंदर भी क्या टाउट्स नहीं है? अगर किसी को बेल लेना है और अगर पुलिस वाला ये कहेगा कि मैं बेल का अपोज नहीं करने वाला हूं, तो ये भी एक टाउट है। गवर्नमेंट ऑफिसेस के अंदर अधिकारी भी टाउट का रोल अदा कर रहे हैं, ये भी एक सच्चाई है। तो ऐसे लोगों के ऊपर अगर आप एक ऐसा कानून लेकर आ रहे हैं कि जिसके अंदर, बहुत खुश होंगे आज देश भर के जितने भी टाउट्स, अगर ये बिल पास हो गया है तो, क्योंकि उसकी पनिशमेंट की पैसे कितने हैं? महज 500 रुपये। मैं मंत्री जी, इस सरकार ने 500 रुपये की कीमत 50 रुपये के बराबर लाके रख दी है, और आप दलालों को कह रहे हैं कि अगर आप पकड़े गए तो हम आपको 500 रुपये फाइन करेंगे, अगर आप दोबारा पकड़े गए तो 3 महीने की आपको सजा मिलेगी। अध्यक्ष महोदय, मैं आपसे ये कहना चाहता हूं कि ये दलाल किस लेवल के ऊपर काम करते हैं, कैसे गरीबों को लूटा जाता है। यकीनन इसके ऊपर फाइन बढ़ाने की जरूरत है। मैं आपके जरिए मंत्री साहब से ये कहना चाहता हूं, आज से 3 साल पहले जब कोरोना आया था, छोटे छोटे दुकानों को, मेरे चुनावी क्षेत्र में छोटे छोटे दुकानों को अपना छोटा छुपके से कारोबार कर रहे थे, तो प्रशासन ने 1 लाख रुपया, 2 लाख रुपया, 3 लाख रुपया फाइन दिया छोटे छोटे दुकानों को। मैं उसके अंदर जब हस्तक्षेप किया, लेबर कमिश्नर के सामने जाके बैठा, आंदोलन किया, तो 3 लाख रुपये की फाइन 3000 रुपये हो गई। उन लोगों को तो राहत मिल गई, लेकिन मंत्री साहब मेरे ऊपर एक केस रजिस्टर किया कि मैं सरकारी काम में हस्तक्षेप कर रहा हूं, पिछले 2 साल से मैं अदालत के चक्कर काट रहा हूं। तो मुझे यह एहसास होता है कि आज इस देश के अदालतों के अंदर अगर लाखों केसेस पेंडिंग है, तो ऐसे केसेस पेंडिंग है। 1 घंटे के अंदर ये केस अदालत के अंदर जाना ही नहीं चाहिए, लेकिन अधिकारी का अहंकार को मैंने ठेस पहुंचाया था तो केस रजिस्टर किया गया है। आज 2 साल से मैं अदालत के चक्कर काट रहा हूं। अध्यक्ष महोदय, मैं आपकी इस बात से सहमत हूं जब आप ये कह रहे हैं कि ये लॉयर्स का जो प्रोफेशन है बहुत अच्छा है, बहुत मजबूत प्रोफेशन है, लेकिन जब यंग लॉयर्स आते हैं, एडवोकेट्स आते हैं, तो इन्हें स्टाइपेंड मिलना चाहिए और इनके लिए भी मदद होनी चाहिए। अध्यक्ष महोदय, मैं लॉयर नहीं हूं, मंत्री साहब मैं लॉयर नहीं हूं, ना मेरे पास लॉ की डिग्री है, लेकिन पिछले 2 साल से मैं औरंगाबाद बेंच ऑफ बॉम्बे हाई कोर्ट के अंदर एक PIL फाइल किया हूं, सिर्फ आधा मिनट, एक PIL फाइल किया हूं जनहित याचिका मेडिकल सर्विसेज को इंप्रूव करने के लिए। और मैं धन्यवाद देता हूं औरंगाबाद बेंच ऑफ हाई कोर्ट का कि जिन्होंने ऐसे फैसले दिए हैं सिर्फ मुझे सुनकर। मैं वहां पर 2 साल से वकील नहीं लगाया हूं। अदालत ने मुझसे कहा कि आप वकील क्यों नहीं लगा रहे, तो मैंने कहा कि वकील कानूनी भाषा बोलेगा। मैं दिल से बताना चाहता हूं कि हमारी मेडिकल सर्विसेज को कैसे इंप्रूव करना चाहिए। इसलिए ये प्रोफेशन बहुत अच्छा है, बस बशर्ते इसके अंदर से जो दलाल, बिचौलिए, ये टाउट्स है, इन्हें हटाना चाहिए। और यकीनन आप इस बिल को लेकर आइए, हम इसका समर्थन करते हैं, लेकिन इसको एक कॉम्प्रिहेंसिव बिल लाने की जरूरत है, हम ये समझते हैं। थैंक यू वेरी मच।
थैंक यू। नेक्स्ट स्पीकर श्री गिरिधरी यादव जी।
सरकार के द्वारा जो अधिवक्ता संशोधन बिल लाया है अच्छी बात है, लेकिन समग्र होना चाहिए। ये बिल पार्ट में, यदि ये बिल समग्र में आता, पूरा आता तो और अच्छा होता। आपने सिर्फ कहा कि टाउट को हटा देते हैं इसमें से, अच्छी बात है, हटा दिए, लेकिन जो वकीलों की स्थिति है, जो शामिल होते हैं, उनकी क्या स्थिति है, वो बीमार पड़ जाता है तो उसका इलाज का कोई इंतजाम नहीं। लाइए पूरी बिल कि जो जूनियर वकील हैं, जो नए वकील हैं, ज्वाइन कर रहे हैं, एकदम बहुत सारा अंतर है। इस देश के सीनियर वकील को पैसा रखने का जगह नहीं है, इस देश के जूनियर वकील को खाने का ठिकाना नहीं है। इन बातों को क्यों नहीं, फीस कौन सा फीस क्या रखेगा वकील लोग? इस देश की जो गरीब जनता जाती है न्यायालयों में, कोई रेट ही तय नहीं है। जो मन माया बोलता हम 20,000 लेंगे, कोई बोलता 30,000 लेंगे, कोई बोलता लाख लेंगे, बोलता कोई ठेका ले लेंगे। आप जब कोर्टों में जाइएगा, आप केस लड़िएगा, आप देखिएगा, गरीबों से बात करिएगा, तो आपको पता लगेगा कि इस देश में न्यायालयों की क्या हालत। अच्छा बिल लाए हैं, दलाल को आप हटाइए, हटाना भी चाहिए, हम लोग भी चाहते हैं कि उसमें दलाल नहीं, लेकिन दलाल न्यायपालिका के अंदर भी है। आपको देखना पड़ेगा कि जो जज और वकील के बीच कहीं कहीं जो कॉन्वेंस है उसको भी खत्म करिए। उसके जो मुंशी हैं उसको तो लाइसेंस है, कैसे हटा देंगे उसको आप? ये बाहर से कोई नहीं आता है, वहीं जो वकील के जो मुंशी हैं और लोग हैं, वो क्या करिए? आप किसी को कहिएगा दलाल है, वो मुंशी अपना वकील बना लेगा, क्या कर लेंगे हम और आप प्रैक्टिकल नहीं है। अब बिल क्या होता है, आप क्या करते हैं इस देश में, बिल को एसी चेंबर में बनाते हैं। आप कभी आपका जिसने बिल बनाया क्या किसी कोर्ट में गरीब से जाके बात किया, किसी जो जेल में उससे बात किया? बिना दलाल में कैसे होगा भाई? वो हम जेल में मान लीजिए कोई मेरा एक आदमी है, उसके घर में कोई नहीं है, कोई आदमी उसको छुड़ाने के लिए गया, उसको अब दलाल बना के जेल में डाल दीजिए, उसको छुड़ाएगा कौन? कुछ लोग उसका दिल्ली कलकत्ता में कॉम्प्रेसिव बिल लाइए, पूरा लाइए कि कैसे हम उसको, आप उसको मदद दीजिए। जिसके कोई परिवार में एक आदमी जेल गया, उसके घर में कोई महिला है, वो कैसे कोर्ट में जाएगी? जेल में टिप्पा लेना, कौन लेने जाएगा जेल में टिप्पा? आपको पता ही नहीं कि जो जो जेल में उसको टिप्पा लेगा तब वकालत फाइल कर सकते। इस देश में वकालत का जो पैसा है बड़ा पैसा, और आप जानते हैं इसका जो वकील लोग क्या होते हैं, देश में क्रांति लाते हैं। चाहे जार के खिलाफ क्रांति हुई हो, चाहे फ्रेंच रेवोल्यूशन हुआ हो, तो सब में वकीलों का योगदान है। और इस देश की आजादी में जितने बड़े देश में आजादी के नेता थे, चाहे वो नेहरू जी हो, गांधी जी हो, सारे लोग पैसे से वकील थे। उन लोगों का कैरेक्टर था, उन लोगों ने देश में दिया। इसीलिए आप जो स्थिति बन रही है, इस स्थिति में हम चाहते हैं ये सरकार अच्छी काम कर रही है, इसको और अच्छे तरीके से करिए कि सब पक्ष को सुनिए आप और रखिए, और एक कॉम्प्रिहेंसिव बिल लेके लाइए। ये बिल तो आप पास करिए, लेकिन जो गरीबों का हालत है, जो बरसों से केस में, अब एक हाईकोर्ट है मेरे पास बिहार में, पटना हाईकोर्ट, आबादी हमारी कितनी है 12 करोड़, आप एक हाईकोर्ट नहीं दे रहे। छोटे छोटे राज्यों को अब 2 हाईकोर्ट दे रहे हैं, मध्य प्रदेश में अब 3 हाईकोर्ट दे रहे हैं। हमको आपत्ति मध्य प्रदेश के हाईकोर्टों से नहीं है, आप क्यों नहीं बिहार में एक बेंच बना? आपको बिहार से सख्त नफरत है। बिहार ने 39 सीट दिया, पहले 31 सीट दिया, लेकिन बिहार के साथ जो नाइंसाफी इस भारत की सरकार कर रही है, वो बिहार की जनता देख रही है। आप क्यों नहीं बनाना चाहते? आप आबादी के अनुसार हम लोग बरसों से जेल में पड़े रहते हैं, इंटेसिपेटरी फाइल करते हैं 6 महीना में आता है, बेल फाइल करते हैं 5 महीने में आता है, बस जज की संख्या नहीं है। हम चाहते हैं एक ऐसा बिल लाइए कि आबादी के अनुकूल हमारे राज्यों में भी बिल, हमारे राज्यों में भी हाईकोर्ट का बेंच बने। नहीं बनाते हैं क्योंकि आपको तो हमारे राज्य से खाली वोट लेना है, जात पात करना है, हिंदू मुस्लिम करना है, वोट मिल जाएगा। आप आके यहाँ खाली गुजरात, महाराष्ट्र, इनका विकास करिएगा। कोई चिंता आपका हल्ला से हमको नहीं है। आपके हल्ला पर मेरा कोई असर पड़ने वाला नहीं। जनता पता कि बिहार की जनता आने वाले चुनाव में आप लोगों का बिहार में क्या असर होगा, जब जानते हैं इन बातों को, हम जानते हैं। समग्र बिल नहीं लाते, आप एकदम नाइंसाफी करते हैं हम लोग के साथ। इसलिए हम चाहते हैं कि बिहार के साथ भी न्याय हो और बिहार में एक हाईकोर्ट का बेंच खोला जाए। इन्हीं बातों के साथ अपने बिल का समर्थन करता हूं, अपनी बात समाप्त करता हूं।
धन्यवाद, धन्यवाद। श्रीमती अपरूपा पोद्दार जी।
Thank you, sir, for giving me an opportunity to speak on this bill, sir. So the bill has been listed for the business so many times, yet it never came up for discussion. सिर्फ तारीख पे तारीख आता गया, लेकिन कोई बात नहीं, देर आई दुरुस्त आई सरकार को। This bill is a very noble, they have brought it with a very noble object, but it's a decade late. The 249 Law Commission report that made the recommendation of repealing the Legal Practitioners Act 1879 was laid in October 2014. Hence, it took for this government 10 years to adopt this recommendation, and this should be brought much earlier. Even when the government has adopted the recommendation, they have done it in a half-heartedly manner. I have some suggestions, though my learned advocate, my senior member have already spoken from my party, Kalyanda have already spoken, but I have some suggestions. The government should have at least come out with some sort of awareness campaign about the practice of tout and it being illegal. Unfortunately, a common man, a sadharan public who have a legal case to fight may not be able to identify a tout, although and end up by paying hefty fees to him, क्योंकि उसको ये लगता है कि अगर इसके पास जाएंगे तो शायद मुझे जल्द से जल्द इंसाफ मिल जाएगा। तो ये चीज जो है, इस चीज पर एक क्लियरिटी होना चाहिए। द गवर्नमेंट यूजुअली एडवोकेट्स टू गो डिजिटल, ये गवर्नमेंट हमेशा कहते हैं डिजिटल इंडिया, सब कुछ डिजिटली, बट व्हाट हैपेंड इन दिस सिनेरियो? व्हाई कुड the government not make a single database when all could be uploaded their tout list? इनको tout list को upload कर देना चाहिए था कोर्ट्स में। This should have helped to mitigate this practice at a larger level and would limit this practice at scale. I beg to this government to make the judicial system more accessible and more inclusive. I am sure the entire House would like to see more robust and equitable justice system. The legal fees is the legal fees taken in throughout the country is not very regulatory. One end, few lawyers who charge a very high amount of fees up to 50 lakh rupees hearing. On the other end, the member of the legal aid cell are paid a marginal fees. In fact, a per capita spending by the government on legal aid is of lowest of the world, just 75 paisa. This is extremely concerning, and I would urge the government to make the system more equitable for all of us. As a policy maker, it is our responsibility to ensure that all the wheels of justice turn smoothly and fairly. Thank you, sir.
Thank you. The next speaker is Srimati Navneet Rana ji.
अध्यक्ष महोदय, आपका बहुत बहुत धन्यवाद. द एडवोकेट अमेंडमेंट बिल 2023. सर, जो ये बिल लाए हैं, इट इज़ अ वेरी स्मॉल चेंज जो मंत्री महोदय ने इस सदन में लाए हैं. एवरी सिंगल मेंबर ऑफ दिस हाउस हैज सपोर्टेड दिस बिल. सर, बहुत साधारण सा ये बिल है और चेंजेस ये बहुत सालों से अपेक्षित था. जो एडवोकेट्स भी अपने जिले में काम करते हैं, जो जिनसे हमसे बात करते हैं, हमारी डिस्कशन होती है. एक ट्राइबल क्षेत्र से, जहां मेरा क्षेत्र ट्राइबल पड़ता है, दार्मी मेलघाट से जब एक आधा किसान आता है या एक्सीडेंटल केस होता है या फार्मर्स की लैंड के कंसर्न होता है फॉरेस्ट के साथ या उनके आपसी फैमिली के प्रॉब्लम्स में, जब वो किसान प्लेन पट्टे पे आके कोर्ट में जाता है, कोर्ट में जाने के बाद वो इतना अनएजुकेटेड है कि उसे हर चीज समझाना बहुत मुश्किल है. तब उनका ट्रैपिंग का जो मामला आता है, जो कोर्ट में पहुंचते बराबर, गेट के पहुंचते बराबर वो वहां पे ट्रैप कर लेते हैं. किसान की जो फार्मर्स की लैंड है या एक्सीडेंटल केस है, तीसरी पीढ़ी आने तक वो सॉल्व नहीं होती है सर. पर उसके केस का निर्णय जब लगेगा, पर वो जो एक आधी एकड़ उनके पास रहती है वो भी बिकने की बारी आ जाती है. तब तक उसका कोई निर्णय नहीं लगता और उसको तारीख पे तारीख दिलाने वाला जो ये इमीडिएटर, जो दलाल वहां पे गेट पे बैठा रहता है, जो आते बराबर उन्हें ट्रैप कर लेता है. इसको हटाने का जो बिल लाया गया है दी बेस्ट है. क्योंकि एडवोकेट से बात करते हुए, क्योंकि नया जब एडवोकेट कोर्ट में आता है तो उसे 2-2.5 साल लगते हैं अपनी सोशलाइट बना के लोगों तक अपना संपर्क करना. तो ये वहां पर ही एडवोकेट को जितने पैसे जाते नहीं है, उससे कई ज्यादा ये बिचौलिया उनसे ले लेता है. और इसमें नुकसान होता है जो गरीब, जो आदिवासी परिवार के लोग जाते हैं अपने केस लेके, या किसान के जो पानधान रास्ते होते हैं, हमारे मराठी में पानधान कहते हैं, पगड़ी रास्ता मुझे कहते हैं लगता है, तो वो रास्ते पे जो वाद होते हैं बहुत सालों तक चलते हैं. उसमें उसके किसान की खेती बिक जाती है पर निर्णय वो बिचौलिया लगने नहीं देता है. और ये हटाकर मुझे लगता है डायरेक्टली जो गरीब वर्ग है, जिन्हें इसकी ज्यादा आवश्यकता है, वो ऐसे किसानों को, ट्राइबल क्षेत्र में रहने वाले लोगों को बहुत ज्यादा डायरेक्ट फायदा होगा. सर, एक और प्रॉब्लम देखी गई है जब हमने सभी एडवोकेट से बात की कि majorly problems what you find when these poor people, needy people come to you, they say we cannot help them in any which ways. I said why you cannot help them? तो उन्होंने ये साफ कहा है, अगर हमारी मंशा भी रहती है कि गरीब महिला कोई अपनी फैमिली कोर्ट में आती है, फैमिली को इशू लेकर आती है, या एक्सीडेंटल में किसी का हस्बैंड गुजर जाता है, तो उन्हें इंश्योरेंस के पैसे मिलने चाहिए. उसके लिए अगर हमें उन्हें डायरेक्ट मदद भी करना है, पर बिचौलिया पहले ही आके बोल देता है कि एडवोकेट साहब इन्हें मदद नहीं करना है, आपने अपने पैसे जो चार्ज करते हैं उससे इतना बढ़ाकर चार्ज करना. अगर 50 मेरा है तो 1.5 आपने चार्ज करना है, उसके कम आपने चार्ज नहीं करना. तो एडवोकेट ऑल्सो बिकम्स हेल्पलेस सर. पर उस दौरान सर इट इज वेरी इंपॉर्टेंट, और वो बिचौलिया इतना फेमिलियर हो जाता है वो परिवार के साथ कि अगर हस्बैंड गुजर जाता है एक्सीडेंट में या एनी विच वेज कि डिवोर्स का कोई विषय चलता है, तो वो इतना फेमिलियर हो जाता है, फीमेल के पास पैसे नहीं रहते हैं देने के लिए, तो वो उनका मिस यूज करती है वो फीमेल का, वो बिचौलिए. तो ये बिल लाकर, अमेंडमेंट लाकर, मुझे लगता है ऐसे परिवारों को, ऐसे किसान को, जरूरतमंदों को जिनके केस कोर्ट में चल रहे हैं और जिनके कारण, बिचौलियों के कारण बहुत ज्यादा नुकसान डायरेक्टली ये गरीब लोगों को होता है, और ये लाकर मुझे लगता है उनको डायरेक्ट फायदा हमारे मंत्री महोदय पहुंचा रहे, इसके लिए आपका दिल से बहुत बहुत धन्यवाद करती हूँ और वी सपोर्ट दिस बिल। थैंक यू।
धन्यवाद श्री संतोष पांडे जी।
सम्माननीय सभापति महोदय, आपने इस महत्वपूर्ण विषय पर और बोलने का अवसर मुझे प्रदान किया, मैं आपका आभार व्यक्त करता हूं। अधिवक्ता संशोधन विधेयक 2023, यह अधिवक्ता अधिनियम 1961 में संशोधन करता है। महोदय, ये जब ये विधेयक आज पेश हो रहा है और सब लगभग हम सभी सहमत हैं, एक समसामयिक 4 लाइन का कोरस मुझे ध्यान में आता है। हो गए हैं स्वप्न सब साकार, कैसे मान ले हम, टल गया सर से व्यथा का भार, कैसे मान ले हम। वेशवाणी तत्व दर्शन दूसरों का यह सभी ले, विकृतियों को ग्रहण करते निज प्रकृति को आज भूले। दूसरों की यह नकल है, अस्मिता क्या मान ले हम, इस पराये
का विषय मैं खुद डील कर रहा हूं। मैंने राज्यसभा में भी कहा है और अभी संविधान दिवस के अवसर पर मैं सुप्रीम कोर्ट बार एसोसिएशन के फंक्शन में गया था, वहां भी मैं कह के आया हूं कि इंश्योरेंस में अगर आपको कंट्रीब्यूशन देने में कोई दिक्कत है तो आप प्रपोजल लेकर के आइए। सुप्रीम कोर्ट बार एसोसिएशन के लोग जल्दी प्रपोजल लेकर आएंगे। हम मिनिस्ट्री ऑफ जस्टिस में या हमारे मिनिस्ट्री ऑफ लीगल अफेयर्स में जहां भी जरूरत होगी, भारत सरकार पैसे देने में कोई कंजूसी नहीं करेगी। जो प्रपोजल विजिबल होगा, हमारे वकील भी इतने ही प्रोफेशनल हैं जैसे डॉक्टर हैं, उनके लिए कोई सिक्योरिटी का विषय आया तो इनके लिए भी हम कुछ करने के लिए जरूर कुछ न कुछ करेंगे। एक विषय आया कि टेक्नोलॉजी का उपयोग नहीं हो रहा है, मेरे समझ में नहीं आ रहा। 10-12 साल पहले कभी आप कोर्ट परिसर में जाते थे तो आप किसी से पूछते थे मेरी पेशी कब है। आज तो साहब वहां मशीन लगी हुई है, उस पर जाके टच स्क्रीन लगी हुई है, उस पर जाकर अपना नंबर डायल करो, उसमें अपना लिखो नाम, आपकी पेशी का पता चल जाएगा कि आपका ये कोर्ट है, इसमें आपकी पेशी है, अगली डेट ये है। जाना ही नहीं पड़ेगा। ये मोदी जी की सरकार है साहब, ये समझ में ही नहीं आएगा। मोदी जी की गवर्नमेंट में ईज ऑफ लिविंग ये हमारी प्रायोरिटी है। और मैं आपको सदन को बताते हुए मुझे परम हर्ष हो रहा है कि ई कोर्ट एक हमारी स्कीम चल रही है, ई कोर्ट, उसमें 7,280 करोड़ नरेंद्र मोदी जी ने सैंक्शन किए हैं। सुप्रीम कोर्ट की मॉनिटरिंग में ये कमेटी बनी हुई है और जहां जहां भी जरूरत है वीडियो कॉन्फ्रेंसिंग